Welcome back. Now we are joined today with two trial attorneys out of Atlanta, Georgia, from the Law Ladies, Holly Waltman, and from Mercy Law, Ecleynne. Mercy, ladies, good afternoon. Holly, we'll start with you. We are seeing some more testimony from the cell phone pinging of the co-defendants who are driving around. It seems to corroborate what Luis Rivera had testified to, and it seems to make for a pretty strong argument.
It absolutely does. And the thing to think about here is that either one of those pieces of evidence, both the word of Rivera or the testimony from this expert alone, would both be subject to cross-examination, and a good defense attorney could poke holes in it if it was standing by itself. But these two things married together, the jury is listening, and these are very compelling and are going to be very difficult to bounce back when it comes time for cross-examination.
I mean, Ecleynne, this seems like the peanut butter and jelly coming together to make the perfect sandwich. When you have the both together, it seems like there's only way to swallow this. And so this seems to be a perfect meld of evidence. What were you about to say?
It is the perfect meld of evidence. At this point, you want to just nod, like you're nodding your client. You're kind of nudging your client, like, hey, not looking too good, buddy. Both of them together, as Holly stated, it does not look really good for him. I think that they got the murder in the bag. However, it's just where the money came from. I think that that's where the defense has like a wedge to come in. It's like, hey, there's just mastermind plan. We have the peons, we have the pawns in it, but who is the mastermind? And I think that that's what the jury is going to really want to see.
Yeah, it's very interesting. And of course, a lot of this evidence is going strictly towards Garcia. We have another co-defendant there as well, Mag Bangwang. And it's interesting to see how that plays out. But let's go back to Chris Corbett, the digital forensic examiner who's testifying on the stand. So while we're taking a break from listening to the live testimony, we are talking here as guests and hosts usually do during the breaks, and we kind of all have the same question. Now, I'll start with this, ladies. It appears that before the trial, our viewers might not have heard, but Mag Bangwang's attorney actually asked to separate or to sever the cases. Now, she cited that the fact that the co-defendant, that being Garcia, was facing the death penalty, and she was not, might be a reason to sever, but also said that because the co-defendant Garcia was facing the death penalty and she wasn't, research has shown that when someone's facing the death penalty, it is less likely to have black jurors, and therefore it would affect the jury pool. Obviously, the judge denied it. That's why they're being tried together. But Holly, at least I'll start with you. At least to me, those don't seem to be the right arguments that needed to be made here. What were you thinking?
Oh, I agree completely. I don't think that those were the right arguments, the right legal arguments that would have forced the judge's hand to try these cases separately. Of course, for judicial economy, a judge is going to want to keep these cases together, but the effective bleed over from having these two things tried as one, I think is going to be insurmountable. But also, this could have been strategic on behalf of this attorney's or this co-defendant's attorney. If she knew the judge was not going to grant it, perhaps she softly got up and argued this motion in the hopes that this would come up on appeal and it would give everyone a whole new shot at a different trial.
Absolutely, that makes sense as well. Ecleynne, similar question. I mean, in my mind, thinking off the top of my head, I'm saying antagonistic defense, meaning maybe Mag Bangwang wants to take the stand and say, hey, I wasn't in the car, I didn't do it. He's the one who maybe heard me complaining about my day, about my clients at the dentist's place, and he's like, hey, I can make a quick bag of money, and he goes directly to the family, and he's the one who commits the murder, and I'm just a stooge. I mean, that sounds like a good defense.
Absolutely. And and I would argue that in my motion to sever, I will argue that the defendant has all the way up until the close of the case to decide if he wants to testify or not. And you are pulling the rug from under him if you have them tried together. I would do any other argument than the arguments that they presented. I bet you would do everything else instead of that. It is an antagonistic because they are just going, it's just playing against each other. I mean, you have a participant that was in there who's already testifying against both the defendants. Now we're going to be going back. It's just confusing to the jury. It's already a confusing case as it is. To have them tried together is even more confusion.
Yeah, I want to agree with Holly and hopefully give the defense attorneys the benefit of the doubt. Maybe this is maybe not to win the battle today, but the war tomorrow. We're going to continue with more live coverage of this case and legal analysis from our experts today here, the Law and Crime Trial Network.
It is certainly odd, and for me, the logical reason would be, or the logical thing to do here would be try all three together, so you do get those missing holes of motive and intent in the storyline. It's been my experience as a trial attorney that jurors want the full picture. They want everything. They take their jobs very seriously, and they want to be able to examine, cross-examine, and question every little piece of this puzzle. For me, I would have anticipated this would be 3 different trials, or it would be all 3 together.
Yeah, I also would have thought that you would get the person who put out the hit to be prosecuted first, and then you trickle down the line and maybe use the person who put out the hit to say, hey, I contacted this person, I'm guilty, now I'm getting them. Then the person who got contacted said, hey, I was contacted by the person who was found guilty, and then I got this person to pull the trigger, and that streamline would have been nice and neat. Again, there's no statute of limitations, so why not? We're going to continue to ask these hard-hitting questions and watch a live testimony here at the Law and Crime Trial Network right after this break.